and 16 entirely on the administration of estates. So on the learning unit 15, we are required to study the JNR prescribed textbook, paragraph 15.1 up to paragraph 15.3, where it's more about introduction, content of the Reform of Customary Law of Succession Act, the definitions, interpretations, order of succession in customary law estates. It's not a big chapter. I tried to summarize what it's actually required for us to understand the Act itself. It came into operation on the 20th September 2010. Its aim is to modify the customary law of succession as to provide for the devolution of certain property in terms of the law of interstate succession. Also to clarify certain matters relating to the law of succession and the law of property in relation to persons subject to customary law. Also, this act, the Reform of Customary Law, it amends certain laws which are Interstate Succession Act 81 of 1987 and Maintenance of Surviving Spouses Act 17 of 1990. I included links to those sections on my PowerPoint. The PowerPoints will be made available after the lecture on my UNISA. On the Act, I want us to focus on the definition of descendant. A descendant is a person who, in terms of the Interstate Succession Act, includes a person who is not a descendant in terms of the Interstate Succession Act, but who during the lifetime of the deceased person was accepted by the deceased person in accordance with customary law as his or her own child, and a woman referred to in section 2, subsection 2B or C of the Act that I attached a link to on the below. I think that wraps up my learning 15 because it's more about the Act itself. The closure of learning 15 is the Reform of Customary Law of Succession Act, which in full is a link that can be opened to obtain such act. And the next unit is purely administration of estate. The Act is to consolidate and amend the law relating to the liquidation and the distribution of the estates of deceased person, the administration of the property of minors and persons under curatorship, and or derelict estates to regulate the rights of beneficiaries under mutual wills made by any two or more persons. Basic concepts of the administration of estates. A deceased estate comes into existence when a person dies, leaving property or a document which is a will or purports to be a will. Such estate must then be administered and distributed in terms of the deceased will, or failing a valid will in terms of the Interstate Succession Act. The procedure which must be followed to administer a deceased estate is prescribed by the Administration of Estate Act 66 of 1965 as amended. At death, the estate of the deceased person is frozen and no one may withdraw funds from the deceased bank accounts or deal with any of the estate assets without the necessary permission from the Master of the High Court. If the deceased was married in community of property, the joint estate is frozen. This situation often creates hardships for the surviving spouse, especially where the bank accounts were all in the name of the joint estate or in the name of the deceased. The residue of the estate. The residue of the estate is what's left after all liabilities, debts, expenses, gifts, and administration fees have been paid. What happens to the residue If a valid will has been left by the deceased, this legally binding document outlines how the residue of the estate passes to the beneficiaries. Solvent and insolvent estate. A solvent estate is one in which the assets exceed the debts. An insolvent estate is one in which the debts exceed the total value of the estate. The administration process have three phases. The first phase of the administration process is the reporting of the estate. Is my slides visible? Okay. Okay, thank you. It is visible. It is visible. Thank you. I'm on slide 7. The estate must be reported to the master of the High Court in the area where the deceased resided, which is the government department which oversees the estate administration process. Documentation and information has to be provided to enable completion of the required forms for submission to the master. Example on completion to the required forms in the administration process. It can be the inventory form that falls under reporting documents. Next of kin affidavit that falls into the reporting documents, and death notice also. Documentation and information has to be provided to enable completion of the required forms for submission to the masters. Example of the documentation that I gave, the 3. The contact person for the estate is given a checklist in this regard to make sure that all documentation are fully completed, and everyone who needed to sign, commissioner of oaths that needed to commission the documents complied with the documentation requirements. Once all requirements are submitted to the master, who will, if everything is in order, issue a document called letters of executorship in favor of the person who is going to act as executor of the estate. Everything in order, sometimes you'll find that the document is missing a stamp of commissioner of oath. A document is missing a signature. It means everything is not in order. That can delay the granting of letters of executorship by the master. Before the executor receives the letter of executorship, they have no legal authority to represent the estate. On average, it can take anything from 2 to 6 weeks, sometimes longer, for the letters of executorship to be issued. Once the letters am I audible?
Yes.
Oh, okay. I'm still on phase 1 to 3, or is it me only that I'm getting lost?
It shows phase 1 to 3.
Okay. Once the letters have been granted, once the letters of executor is granted, is issued, a liquidation and distribution account can be prepared. This is a financial statement in the format prescribed in Section 35 of the Administration of Estate Act, which details the assets of the estate, its liabilities, including administration expenses, income tax, and estate duty, and reflects the awards to each of the beneficiaries and heirs. Once this account has been completed, the following must be attended to. The account must be submitted to the master together with all supporting documentation. After the executor has done the final tasks, they are entitled to be discharged, also referred to as obtaining a filing slip from the master. Executor. A definition of an executor in essence is Executor of an estate is someone who wraps up a deceased individual's financial affairs. If the deceased has a will, the will surely names close relative, friend, accountant, attorney, or financial institution to act as executories. On the administration of estates on Unit 6, we are all expected to fully study and understand the uniform rules for the administration of deceased estates. As I already stated on the phases, phase 1 to 3, basic concepts of administration of estates. The estate, what is an estate? Executor, what is an executor? What happens to insolvent and solvent estate? What is it expected to be done with the residue of an estate? I think those are the outcomes that we need to stress ourselves with, that we need to fully understand. What are the master's duties when coming to the administration process and all. I think we're reaching the end of my slides. We're going to have a question and session for both Unit 15 and 16. And the other questions on the chat box can be typed there. And if the time finish without you getting a chance to ask a question, can always send an email. We'll try to answer your question. That's the end of my presentation. Open for questions.
Buledi, I'm just going to try and activate the microphones for everybody. So in the meantime, maybe just check if there's questions on the chat, and I will let you know as soon as I don't know why every time I have to figure out this from the start. How?
Okay, Prof, I'll check the chat box so long.
Okay, I have enabled everybody's microphones. They must just unmute themselves again before they ask a question. Thank you.
Thank you, Prof. No questions. Oh, okay, Jabulani, can unmute yourself.
Yes, good day, ma'am. My question is about the the very same chapter of customary marriage. If now the husband has passed on and had 3 wives, and these wives are houses in his land, so how do you regulate the administration of the estate in that case? Thank you.
Breaking.
I listen.
Jabulani, you were breaking.
I was saying. Okay, let me start afresh, ma'am.
Okay.
My question is about a husband who has died, who has 3 wives.
Yes.
And these 3 wives have got their houses in land. So
okay.
in terms of executorship, and there is no will, in terms of executing the estate, how does one goes about in that case, since there are 3 wives and they've got 3 houses within the land and they've got 5 children? That means each wife will be having 2 children and other 1 child.
Each wife have 5 children, or?
No, each wife has got 2 children.
Each wife
2 wives have got 4 children, divided by 2 children, and the other wife has got 1 child.
Oh, okay. Now what happens is the family have to sit and agree as to who is going to be appointed as executories of the family. I believe if the deceased married in customarily, they all know, remember customary law, one of the requirements is that the elder wife has to give consent to the marriage of the second wives or the third wives. So it means they know each other. They have to now decide who is going to be nominated to be appointed as executor to the masters. And upon appointed as executor to the master, they have to do the whole administration of estate. That doesn't mean immediately when you get a letter of executor, you own everything. We have to follow a right procedure. We invite creditors, we advertise in the government gazette, we advertise in the newspapers, the creditors are coming to claim and everything. And then when everything is complied with, according to the administration of estate, and now we know that you are dealing with solvent or insolvent estate. For example, I'm going to say the estate it's not insolvent. So now we have a residue of the estate. Né? And then what is left from the estate is going to be distributed amongst the beneficiaries. That's where now the child share kick in. Remember when you were writing your assignment, a written assignment, you were asked to do a child share calculation. That's where now you're going to say the deceased had 3 wives and how many kids, and the residue of the estate is this much after dealing with the admin of estate. And then this is how you're going to make sure that each beneficiary get the share accordingly in terms of the child share. Are you answered, Jabulani?
Yes, ma'am. Thank you for clarification.
Okay. I saw a hand while Jabulani was speaking. I saw a hand, but now it's down. They can ask the question or leave the question in the chat box.
Probably it was my hand. I've lowered it down.
Oh, okay. So there's no question. You all understand unit 15 and 16.
There is a question here, Nkosinati.
Oh, okay, Nkosinati.
Hello, ma'am. How are you?
I'm great, and you, Nkosinati?
I'm okay. Ma'am, I have a question here.
Okay.
Let's say the deceased now has died and all his estate are being frozen, only to find out he was married and
Yes.
and then they had maybe some complications with the wife. Now that he's gone, the family don't have a wife that his husband is no longer with us. So what's the procedure there? How do we distribute his estate?
Okay. The wife and the deceased were still married.
Yes.
Okay. And there's no divorce and there's no proof of divorce.
Yes. Yes.
Then in that case, the rightful person is the surviving spouse to be appointed to the letter of executor.
Okay.
Yes, remember on your child share when we calculated that the brother or the parent of the deceased, they are excluded to the inheritance because they are not direct beneficiaries.
Yes, yes.
Yes, their problems, their marital problems have nothing to do with the administration of estate. If the deceased wanted to be out of that marriage, they would have filed for divorce.
Okay.
Yes.
Okay, thank you. Thank you.
Okay. I saw another hand. Ndombi Zodwa. Yes. Yes, Tomizot. Okay, the hand is done now. Leslie, yes, can come through.
Good day, ma'am. I just want to find out the decided case of B versus the magistrate Khayelitsha. What effect does it have on the customary law on what you have just presented? Thanks, ma'am.
I didn't hear you properly.
No, I want to understand what connection does the decided case of B versus the magistrate of Khayelitsha with the customary law? What effect, what's the difference there? Does it have any effect on the customary law that decides this case?
You want to understand the B versus Khayelitsha. Can you give me the full citation of the case?
No, what happened, it was about customary law, whereby normally the brother is there when the husband dies, then the brother takes each and everything over. Now I want to understand this case. Does it also apply on what you have presented or not, or was he just trying to separate the two things to say from this day, 27 April 1994, that customary thing does not exist. This comes into law now.
Well, lady, can I come in?
Yes, you can.
Brother Leslie,
Yes, sir.
remember, it has effect on customary law, that decision, because you remember, according to before, when we define a child share, the child share was that the child share is calculated by dividing the value of the interstate estate by the number of children who have either survived the deceased or who have predeceased but survived, plus the number of survivors plus one. But now,
Okay.
ever since that case, it is no longer plus one, but it is plus the number of surviving spouses. As a result, it recognizes those wives that were married customarily so.
Okay, no, thank you, sir.
Pleasure.
All right.
Well, lady, you can continue.
Thank you, Mr. Matsimela. I didn't get the full citation of the case, but thank you for answering. We have another hand, Ntombizotwa, Rachel, and Miriam Tennis. Ntombizotwa, you can ask a question.
Good day, ma'am.
Good day.
I would like to have clarity on the situations of spouses. There are spouses who usually divorce, and after divorcing, they stay together in the same house and continue doing the things they've been doing before the divorce. So,
Okay.
and they don't have wills. So,
Okay.
if one of them dies, what happens to the estates?
If one of them dies, do they have children?
Let's say the children are old or they are not
Yes.
staying with them anymore.
Okay, even if the children are old, they are the ones who are going to be entitled to the estate of the deceased. As for them, as living as girlfriend and boyfriend under one roof, remember they decided to dissolve their marriage.
Yes.
So there is no longer any matrimonial regime pertaining to them under one roof. So they'll be seen as a girlfriend and boyfriend, and none of them can claim anything against each other.
Okay. Thank you, ma'am.
You're welcome. Miriam, yes, you can ask.
Okay, hi, good day.
Good day.
Yes, so my question is like according to customer law dissolution. So my question is on when you mentioned that a wife, sort of like the first wife decides who now has to like be the executor, right? Or something like that. Now my question is, if there was a will that was written in terms of that customary law and they appoint someone within the family, does that also like affect how they're going to like receive their share in that family setting?
Miriam, the first wife can be nominated or not nominated. I said they can agree as a family as to who must be appointed as an executor of the estate. If there was a will, the will ought to dictate who the executor should be. Remember, Yes, remember on my slides, oh, how do I go back to my slides now? Can you still see my slides?
Not yet, no.
Not anymore.
Yeah.
Okay. On my slides, on phase 1 to 3, the family have to, do you see the slides now?
Yes.
Do you see the slides? Okay. The family have to agree as to, oh, I can't see them now. They have to agree as to who is going to be appointed as an executor. If the will does not dictate who the executor should be, then the first wife or the second wife is going to be appointed, or the third wife. The executor doesn't necessarily mean they have power over the estate or something like that. No. Theirs is to make sure that the administration of estate is well executed, and upon completing the administration of the estate, they get a filing slip from the master to be discharged from their duties. Hence, there's a certain fee that they get. I think it's 3.5% executive fee currently. So yours is just to be executor of the administration of the estate. It doesn't mean now everything belongs to you, no.
So now, is there like a specific difference between the customary way of distribution and the testate way of distribution, where the marriage is a civil marriage?
The civil marriage and the customary marriage bears the same way of distribution, because it's regulated by intestate succession. There's no will, so it's not testate.
Okay, I get it.
You get me?
Yeah.
Okay. Ntombi Zodwa, it's another question, or your hand still up? Oh, okay, it's down.
Buledi, it seems as if everybody has asked their questions. So I
Yes.
think we can stop. I think next week we scheduled a question and answer session. I am on leave next week, but Prof. Jamnik will be here. But we will give a final information on the module side, because it also depends on load shedding schedules and stuff like that. But yeah, we will. There won't be a formal lecture, but we will probably be available to answer questions. Okay, that is, I mean, Prof. Jamnik and the other lecturers. I'm going to say goodbye now. I don't know if you want to take more questions. It's up to you.
No, it's fine, Prof. We will leave. It seems, oh, Patrick Matula, here's a hand.
Yes, Prof, I put on the chat, going to do Khartoum.
I can't hear you.
Saying, I think we missed one unit, unit 14. Last week it was promised that we'll start with 16.
You missed one unit.
Unit 14, it was not done last week.
Unit 14.
Yes, Khartoum.
Succession by contract. I think it was done.
No, the last.
Okay, let me check for you.
I wasn't here last week, but Mr. Matsamela gave a lecture. Did you do Pactum Sequestorium, Mr. Matsamela?
Last week I did an interpretation, and then I promised that, okay, this week this one succession by contract will do it this week.
Okay.
So maybe
So-
we can do it. We can do it next week before question and session. I think
Okay.
it's short.
So you don't have a lecture for today?
No, I don't have. I'm so sorry.
Okay, so before the question and answer next week, we start with learning unit 14.
Yes.
Okay.
I thought maybe you will do it today, but since then you were focusing on 14 and 15. We'll deal with it next week, maybe for 15 minutes before we start with the question
Okay.
and session.
Okay, not a problem. We're
Thank you.
sorry about that.
Sure.
Namsile,
Hello, ma'am. How are you?
great and you?
I'm fine. I want to ask, in customary marriage of 3 wives, how the estates will be dissolved if one wife die interstate?
Interstate.
The other 2 wife will able, yes, the other 2 wife will able to inherit on the other wife estate.
Who dies, the husband or the first wife?
No, the first wife.
The first wife.
Yes,
Remember, the first wife is only married to the husband, not the other
yes.
wives. So
Oh, right.
the marriage is dissolved between the husband and the wife. So meaning the inheritance will go to the surviving husband.
And descendants only.
Yes.
Okay, thank you, Prof.
Okay. Leslie?
Ma'am, thanks. I'm having a technical problem. The site is seeing the whole slides. I hope that you'll post it so that I should follow it from that side. Thank you.
Okay, the slides will be posted on my UNISA, Leslie.
Thank you so much, ma'am.
Okay, you're welcome.
Okay, I'm going to stop the recording now, and I think we can stop the lesson as well, and then next week we will see the students again.
Okay, Prof. Thank you, everyone.
Okay, thank you, lady.
Thank you, Matimela.
Thank you, everybody.
Bye.
Sure, sure.
Thank you,
Bye.
Prof.